Recently, a UCLA lecturer was placed on leave because in his email he expressed that providing academic accommodation to Black students is considered as a type of special treatment, which is against the whole idea of equal treatment. So in history, there has been a lot of efforts try to provide equal opportunities, such as constitutional amendments, legislations, executive orders, important court rulings with the interpretation for the legislations. And Civil Rights Act of 1964 is a landmark to provide equal opportunities. It is passed during the Civil Rights Movement in the 1960s to prohibit the discrimination among many different areas such as voting rights, education rights, employment rights. So today we focus on the employment rights, which is the Title VII of Civil Rights Act of 1964. So the content of Title VII is it prohibits discrimination by employers based on race, color, religion, sex, and national origin on employment decisions. The employment decision including such as firing, hiring, conditions, and privileges of employment. So does that apply to other employers? No, it covers the employers who has more than 15 employees who works for more than 20 weeks per year. Is there any exceptions? Yes. Important one is called bona fide occupational qualification, which refers to the situation where employer is actually permitted to discriminate against a trait if a trait is reasonably necessary for normal operation of the specific business or enterprise. So if you want to hire someone to play the role of former President Obama in a TV show, and you only choose the actors from African American candidates, it's not considered as discrimination because it's a reasonably necessary requirement to ensure the normal operation. And there are also some other issues you need to know. For example, the definition of sex. When the act was passed, it only considered the traditionally biological gender, male, female. However, the definition has become more complex. So some questions for you to think about. Should they cover the transgender people? Should they cover sexual orientation? How about gender identification, where people psychologically identify themselves differently? So throughout the days, the boundary has been challenged, and I will share more cases regarding to these definitions. There has also been supplement to Title VII to protect more traits such as disability, pregnancy, and age. And in some cases, the companies might discriminate unintentionally. For example, the adverse impact against race is actually due to a referral system they have. So in these cases, we use 4/5 rule. The rule of thumb is that whether the selection rate, the hiring rate of a protected group is less than 80% or 4/5 of the majority group. So here we are comparing the hiring rate, the rate of hiring instead of the actual number of employees being hired. And business needs to take actions to provide these equal employment opportunities and avoid discriminations. And there are a lot of things they can do. For instance, provide reasonable accommodations, provide maybe a channel for anonymous report for sexual harassment, and value the diversity in your organization. So at the end, I want you to share your opinion about a case where Hooters, a chain restaurant, only hired female for their server's position. They turned down the male applicants for this position. Do you think this requirement of gender should consider as bona fide occupational qualification under the essence of business? Leave your comments below.